Welcome to AD Dictation. Please subscribe the channel and hit the bell icon to get latest updates at first. If you have any query, then please let me know in the comment section below.
Ready, start. From the above narration, it is no doubt seen that all the three courts have held against the appellant and have sentenced him accordingly, though in that circumstance the reappreciation of evidence which led to the conviction may not arise. This court is certainly required to examine as to whether the requirement contemplated under the Act 1954 and the Rules 1955 has been complied with by the authorities as per the requirement in terms of the safeguard provided therein. The primary contention of the learned counsel for the appellant, as noticed above, is that in respect of the sample said to have been collected on 16/10/1979, the report was submitted by the public analyst on 15/11/1979, indicating that the milk sample was deficient, which was below the prescribed standard, and hence the sample was reported to be adulterated. Pursuant to the such report, a complaint was filed before the learned magistrate on 18/3/1980. Subsequent thereto, the copy of the report of the analyst is stated to have been dispatched to the appellant on 7/4/1980. It is that view the contention has been raised by the learned counsel for the appellant that the same is in violation of the provision contained in section 13 (2) of the Act 1954. In this regard, it is contended that subsection (2) to section 13 of the Act 1954 provides that the authority, on receiving the copy of the report of the result of analysis and on institution of prosecution, forward a copy to the person, and it would be open for such person to make an application to the court within a period of 10 days from the date of the receipt of the copy of the report to get the sample of the article kept by the local (health authority) analyzed by the Central Food Laboratory. In that regard, Rule 9b of Rules 1955 provides that the local (health authority) shall send the report based on which the action is taken within 10 days after institution of the prosecution. Such report is to be sent by registered post to the person from whom the sample of the article was taken by the food inspector. In the instant case, the contention put forth is that so much report of the analyst has been made available to the appellant and there is no proof of delivery of the report. It is contended that even though the prosecution had stated that the report was dispatched on 7/4/1980, keeping in view that the prosecution was instituted by filing the application before the learned magistrate on 18/3/1980, the very alleged dispatch of the report is beyond the period of 10 days as contemplated in the rules as stated above. On this aspect, learned magistrate, while rejecting the contention, has held that the report of the public analyst was sent to the appellant by registered post on 7/4/1980, which is within the period of 20 days, and since such report was sent within a reasonable time, the appellant cannot be said to have been prejudiced in any manner. Stop.